Hey man, colored or white?
White.
In the front.
Thank you.
Colored or white?
Color.
In the back. Hey man, colored or white?
White.
Right. In the front. That is colored or white?
Colored.
Are you sure?
Yes, sir. I'm 1/8 black.
Alright, I'll take your word for it. In the back. Hey, I thought I told you to go to the back.
No, sir. I'm staying right here.
Officer!
Yes? What seems to be the problem here?
I told this colored man to go to the back.
This man doesn't look colored.
He is. I punched his ticket. He said so.
You're right. Well, you won't be needing this anymore. You're coming with me.
Ah! 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 Blah, blah, blah. Blah, 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 blah.
Order! Order! Here I have the final verdict passed down in the court case of Homer Plessy versus Ferguson. This case turns upon the constitutionality of an act of the General Assembly of the State of Louisiana, passed in 1890, providing for separate railway carriages for the white and colored races. The constitutionality of this act is attacked upon the ground that it conflicts both with the 13th Amendment of the Constitution and the 14th Amendment, which prohibits certain restrictive legislation on the part of the states. By the 14th Amendment, the states are forbidden from making or enforcing any law which shall abridge the privileges or immunities of citizens of the United States. The object of this amendment was undoubtedly to enforce the absolute equality of the two races before the law, but in the nature of things, it could not have been intended to abolish distinctions based upon color. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the races stamps the colored race with a badge of inferiority. The argument also assumes that social prejudices may be overcome by legislation and that equal rights cannot be secured to the Negro except by an enforced commingling of the two races. Legislation is powerless to eradicate radical instincts or to abolish distinctions based upon physical differences, and the attempt to do so can only result in accentuating the difficulties of the present situation. The judgment of the court below is, therefore, affirmed.
Ah!